Okay. Well, I want to thank everybody for attending today's Secure Act webinar. We've got well over 1,400 people who have joined the call, so please know you're not alone in your interest. The Secure Act is the single biggest piece of retirement legislation that we've had in our country since the 2006 Pension Protection Act, since 2006. And that's the same year that the Saints returned to the Superdome after Hurricane Katrina, Google buys YouTube, and the Dow crosses 12,000 for the first time, that 2006. The intent of this act is it's designed to make and improve retirement security by making saving for retirement easier and more accessible than ever before, all while reducing some of the burden for employers. So for us retirement geeks, this is a really big deal, and we're excited about it. But as an employer, there are things that you're going to need to know. And the good news is we've got the right people on this webinar to speak about the Secure Act. My name is David Reich, and I'm Hub's President of Retirement and Private Wealth, and I've been in financial services for over 20 years, and I'm passionate about helping employers help their employees better prepare for retirement. Also joining me on the call is Joe DeNoyer. Joe is a retirement practice leader at Hub and is the president of Washington Financial Group, a division of Hub International. Joe is an ideal advisor to join us because his experience is really helping plan sponsors cut through the noise and focus on what's really important specifically to them, and that's especially important with the Secure Act. Joe's been practicing for almost 30 years and has been a thought leader every single one of those years. He's won more industry awards than we have time to mention, but I will highlight that he's the past president of the National Association of Plan Advisors, and he has spent a ton of time on Capitol Hill working with lawmakers on what is now the Secure Act. He's proud of advocating for both participants and for employers. We also have Tom Clark, a partner at Wagner Law, on the webinar. We asked Tom to join the webinar specifically because of his expertise in all aspects of employee benefits, including design, implementation, and compliance of retirement plans. He really is one of the go-tos in our industry for all providers for ERISA compliance. And I think most impressively, his vast experience in defending employers and fiduciaries in all arenas, whether it be with the IRS or DOL investigations or through litigation, including working on some landmark ERISA cases such as Tibble versus Edison, a case that went before the Supreme Court. And so with that, I'll turn it over to Tom. Tom, what can you tell us about the Secure Act? Give us some background.
Thanks, David. I'm happy to be here with everybody. Let me make some sort of table setting comments for everyone on the phone. So first off, those of us in the retirement industry were happy and surprised we actually got the Secure Act. There were folks like Joe on the phone with us today who were working their tails off in DC to make this happen. This was not a done deal until very, very, very late when we found out that the president would sign it and would get passed through Congress. There has been various versions of this legislation that have gone through different iterations, had different names, generally tried to achieve similar goals. But to get this one across the home plate was only something that really came to fruition in the last few days before the end of 2019. So kudos to all those many nameless folks who helped. So what is the Secure Act, right? Its technical name, setting every community up for retirement enhancement. So let me set the table for folks. There is nothing about this statute that has a common theme or story through it. Unlike other statutes, when they're passed by Congress, signed by the president, you usually can kind of start at the beginning, go through the middle, go to the end, and it has a common theme, a common story. It's very easy to see how everything is threaded together. So think of a metaphor, right? My wife this past Thanksgiving sets up a menu, sends me to the store with a list, and at the end of the day, when she's done cooking or we're all done cooking, the meal is going to have a theme, right? It's all going to kind of fit together. Everything's going to complement each other. The Secure Act is more akin to me handing my credit card to my 4 sons, sending them to the food store, and having them come back with whatever each of them wanted. And there's not going to be any common theme amongst what they're eating. Same sort of thing here. I'm going to do my best today in the next, let's say, 30 minutes or so to kind of go through the major provisions of the Secure Act. But you're going to find that as I'm going through, that there's no continuity from one slide to the next, right? One doesn't build up necessarily on the other. It's all going to be separate little projects, separate little pieces, separate little ways that the law has been changed or carved or polished or whatever metaphor you want to use. And the overall goal is, and it may not be apparent on the face of the provisions, the overall goal is to increase participation, increase employers offering plans, help the ultimate participant. But it's done through just a number of series of very highly technical changes. And that's the other aspect that people on the phone are going to get today, that I'm going to do my best to explain this stuff in plain English rather than in ERISA lawyer legalese. But some of this may just be difficult to understand because we don't have hours and hours and hours to lay the groundwork for the current rules. And so to the extent I can address them, I will. But essentially, it's, again, a lot of polishing, of changing of this provision and a changing a little of that provision. So that's the first thing I want to say. The second thing I want to say to set everybody up for my going over the Secure Act is, and this is probably the most important thing that I'll say at the beginning before getting into the technical aspects, there is nothing here that makes the house on fire that you have to do right away, right? That there's, unlike some statutes when things change in other areas that you as employers are responsible for, where you've got to literally do something in the next week or you're going to be in trouble, there's nothing like that in the Secure Act. There are a handful of required changes for plans, but the vast, vast majority of them come in over time. Your provider will send you amendments. The amendments can be done. You have to operationally follow it, but nothing is on fire. The vast majority of provisions that change in the Secure Act are optional. And so some of them have to do with establishing plans. I'm going to assume for the most part the folks on the phone listening in already have plans. So even though I'll talk a little bit about that, it's not going to be applicable to you. But a lot of the changes are optional. And so what's the end goal that you should get out of listening to all this today? We're going to sort of wrap it up at the end after I'm done talking about the technical aspects. But the goal should be, after listening to this, that you sit down and meet with your advisor or consultant, and you're going to have time to talk about how all of this smorgasbord of stuff applies to your individual plan. Because if I have, there's a lot of people on this call. If there are, 500 different or 1,000 different plans on the phone represented by the people on the phone, this law potentially applies to all 500 or 1,000 differently, depending on what your provisions look like, what your participant pool looks like. Do you have an older workforce, a younger workforce? Do you have more part-timers, less part-timers, more highly compensated, less highly compensated? There's no way. So it's nice to know that the rules have changed, but the real magic is going to be when you step back after listening, meet with your advisor or consultant, and apply specifically what's here and what's offered in this new law to your specific plan. That's really only when all of this is going to make sense and truly be beneficial, although, of course, we're grateful for you getting on the phone and listening today. So, all right, so let's dive right in, right? Here's a quick summary that we have, something for everyone, plan sponsors. So one of the first major things, and I'll get to this later in the slides, are what's now called pooled employer plans. This is the idea of different employers coming together and sponsoring the same plan, similar to the concept of MEPs, multiple employer plans, if everyone's heard of that. There were some very complex rules. We'll get into it later. They changed it to encourage employers coming together and offering those types of plans. Increased tax credits for people sponsoring new plans. So again, if most of you have plans already, that's not going to apply. But for those of you who don't, they have increased tax credits to make that happen. There's some fiduciary relief regarding the selecting of lifetime income providers. There had been a safe harbor passed a number of years ago, but it didn't. Many people felt it didn't go far enough, and so we'll get into those changes to better protect plan sponsors. There's also, which is a little scary, bigger penalties for when when you mess up as plan sponsors, late with things, so on. We'll talk about that. So for workers, we have some auto enrollment caps raised. The general consensus is that the cap that was there was not high enough, and so they raised it because the general thinking now amongst financial planners is people need to save even more than we thought, years ago in order to get to a sound retirement. One of the major provisions that's going to be required when it's implemented in after 2021 is a brand new provision for part-timers, people you have in your workforce that may not be eligible for the plan at the moment, but could be under the rules that we'll talk about later. That's probably one that everyone on the phone is going to need to, perk up their ears and listen. And then also a change for workers, they've allowing distributions out of the plans for adoption to cover costs related to adoptions and births. And we'll talk about that. For savers, the required minimum distribution rules have been delayed from 70.5 to 72. That is good for people who are living longer, right? If they don't want to take that money out sooner than they need to. IRA, so there was also a previous rule for IRAs, certain capped age, you couldn't contribute anymore. Again, we now live in a world where people work later in age, and so those rules need to change to catch up with modern times. Also, we talked about, or what's going to talk about later, is lifetime incomes options being portable. Right now, generally, those are stuck on certain platforms and they're not movable. There are now rules where, under certain conditions, those lifetime income options can be transferred to other plans or IRAs, and we'll talk about that. And then for the financial planners out there, or folks who work with financial planners, the stretch IRA has been eliminated, and we'll talk about what that means. And that is of much concern to our financial planning folks out there, because strategies that people have been relying on and putting in place are now no longer available. So, okay, so let's talk. First 401k plan change, new auto enrollment cap. So right now it's at 10%. We're for plans that have auto contribution rates. We're talking, the law allows that to go up to 15%, and so this begins for plan years after this year. This is a nice change. Again, this acknowledges the fact that 10% used to be sort of the all-American number you heard from financial planners, and now we are up to 15. Generally, if you queried your financial planning folks out there, they say that savers need to be saving 15% of their salary every year. And so now this change is available to allow that to automatic increases up to 15. Generally, the thinking is, and I'm sure you've heard this from your advisors, is that participants, if it happens automatically, tend to not change the rules. And so if you can automatically encourage them to save more, they will. So that's a very favorable change. They have, so again, switching completely to something else, for safe harbor plans, they have for those with non-elective contributions, meaning you can't, it's not discretionary, it goes in on the behalf of the plan sponsor, the company. There's no more notice requirements. So before you used to have to send certain requirements, those notices are no longer required. If you have those going out, your provider is going to follow up with you. If you had a provider, if you have a plan that meets this, your provider's been doing this automatically, it's part of your service agreement, those providers are going to be making phone calls to you if they haven't already to let you know, and those will be eliminated moving forward. There also have been for safe harbor plans with non-elective contributions, some complex rules about you being able to change the plan design up to once a year. They have now, used to be able to not do it after a certain time period, the 30th day before the close of the plan. So they've now changed that. You can have some more flexibility on timing, but if you change it during this last window, the contribution has to be increased to 4% rather than 3%. So what they're saying to folks is, yes, you can change, yes, you can do all these things, but everybody has to win by getting more money. And so again, favorable to the workers and savers out there. And this is effective now for plan years beginning after this past New Year's. Third 401k plan change, again, no connection to the last two. there has been an increasing arrangement where people were allowed to take plan loans through credit cards or debit cards. My understanding is that there has been certain abuses. People have not liked this. It was too easy to take money out of plans. There's a number of different reasons for this, but to the extent that they were there from a policy perspective of protecting participants, people didn't like this and they wanted it to go away. It's not something that they had endorsed. It was really one of those things that had just been adopted in the marketplace as practice without a law specifically addressing it. Well, now we have a law specifically addressing it and they don't like it. And so effective immediately, if your plan allows loans to be taken out on credit cards or debit cards, you're not allowed to do that anymore. And if you do that, then you're going to have plan error, operational issues, and have to go get corrected and all of that. So if you're doing that, it needs to stop. More likely than not, the providers that are doing it for you will know that and will work with you to do that. But loans are now going to have to be taken the traditional way through paperwork, checks, and so on. Okay, so this is an interesting one. So there's long been discussions that no money should be taken out of a retirement plan. Retirement plans are for retirement, and so money shouldn't be allowed to be taken out until you reach retirement age, and that is traditionally the normal rule. But over time, there have been exceptions for hardships, for loans, your first house, and all these other different things that have popped up over time. They have allowed people to take money out of plans as distributions or to pay it back. Now they have added birth and adoption to that list of reasons that you'll be allowed to take money out of a plan prior to the default, which is at normal retirement age, 60, 65, 59 and a half, whatever it might be. So the change is that you are allowed to take out up to $5,000 per birth or adoption. It is limited to adopting children under 18 or physically or mentally incapable of self-support, not adopting a child of the taxpayer's spouse. So I've got stepsons, I can't adopt them and take that money out. It applies on an individual basis. My understanding is one spouse can take out 5 out of their plan, another spouse can take out 5 out of their plan. It's not combined. And let me just pause for a moment. And that's a good segue to say it is entirely possible that all of us on this call, me right now for the 30 minutes, Joe and Dave when we get them back on in a little while, we're going to say things under our current interpretation of all of this. And it is entirely possible when a set of regulations comes out later that everything we've said is wrong because it's based on an initial reading. But once these laws get into the hands of the agencies that enforce them and write regulations, that the regulations can completely upend what we all thought the law said. That happens more often than people realize. And so again, my analogy here is this is not like a new season on Netflix where you can simply stream through every single episode and binge watch it. This feels much more like a Netflix show or, The Mandalorian on Disney Plus, if everyone watched that, where you have to wait each week, for the next episode, or sometimes like Star Wars movies, 2 years, right, to find out what the next chapter in the story is. This is much more akin to that as a metaphor, that yes, we have part of the story, but the final version of the story is not going to be written in a number of these areas for years because we're still waiting for regulations. And so again, I may say something on here. This is my best interpretation right now from what we can tell. I am the first to admit I may be entirely wrong on something because the IRS or DOL is going to undermine and or it just will take on a different meaning over time based on how it's actually applied to actual plans in real life as opposed to generalities on a statutory page. That's pretty normal in our ERISA world. So birth or adoptions, penalty-free withdrawals, and this is applicable starting now. So for plan years in 2020. So this is one of those ones that can be added to a plan if people feel that is beneficial to their plan participants. So probably the one with the most profound effect for everyone. Reminder of what the current law is. We are allowed to exclude employees who work under 1,000 hours a year, the part-time rule. Governmental plans don't have any limits, but for any of the plans subject to ERISA, it's 1,000 hour. You can't prohibit somebody from being in the plan if they work more than 1,000 hours in a year. It's a very gross generalization of the rule. But what that means is there's a number of people who work part-time who don't have access to the retirement plan to save for the employer they work at. And since the general goal of the Secure Act was to increase the availability of plans to participants, we have this new long service part-time employee rule. And so the idea is starting January 1st, 2021, that's my understanding of what it says, so no past credit, but starting January 1st, 2021, if you have employees who work 3 consecutive years or 500 or more hours, which could be an incredible amount of folks who seasonal, right? If you have seasonal, especially with overtime over the summer, that makes these people eligible. They will have to be offered eligibility into the plan, but only to defer salary. Age 21 requirement is still permissible. So if it's 18-year-olds, you can still exclude them. But anybody over the age of 21 who works 3 consecutive years, 500 hours or more, I believe, after January 1st, 2021, you have to let them into the plan. However, they're not going to be counted towards discrimination testing or any kind of testing for employer contributions. All you have to do is allow them to defer their own salary. So this is a nice compromise, right? It allows people access, but doesn't necessarily upset the apple cart for those who have very distinct workforces with part-time folks, and that if all of them had to be allowed and paid the employer-agreed contributions like matching or money purchase or profit sharing, safe harbor, you potentially could get that employer, the plan would be so expensive they wouldn't want it anymore, or would have to pare down benefits. This is a compromise. Doesn't mean, let's gut check for a second. You can let anybody into your plan at any point. So right now, if you have immediate admission, probably nothing needs to change about your plan because this isn't going to apply, because anyone who starts working for you for 1 hour is allowed into the plan. But this really applies to people who have that part-time rule. Anyone under 1,000 hours isn't eligible. So Dave and Joe will talk a little bit about, I think later, about planning for this now. You can start doing planning now and getting ready for this for later. So another change, soft frozen defined benefit plans. This may not really apply to anybody on the phone if you have a closed defined benefit plan, meaning no new people are allowed in, but benefits are allowed to be increased. This is a highly technical change where you get some discrimination issues towards highly compensated, as the highly compensated employees tend to stay around longer, the lower paid employees tend to leave, and so you can have some real testing issues for the defined benefit plan, and things can get out of whack. This is more of a relief provision that says, okay, you can do some different kind of testing as we recognize this sort of happens. Highly technical. If you have a soft frozen defined benefit plan, which I might say 2 of you, I'm going to guess 2 of you on the call may have, then you're going to be talking to your consultants, advisors, actuaries quite soon about this. But if not, this doesn't apply to you. So increased penalties. So failure to file your Form 5500 goes up to $250 per day, not to exceed $150,000. That is a lot of money. And unfortunately, in my career fixing retirement plan errors, this is something we see more often than I wish. So this can get very expensive for folks. Failure to file a registration statement, $10 per participant, not to exceed $50,000. That's an increase. Failure to file a required notice of change in status, $10 per day, not to exceed $10,000 for any failure. Failure to file a required withholding notice, $100 per failure, not to exceed $50,000. So this was just a quality of life housekeeping change on the part of the government, that they felt the penalties were too low and maybe were not punitive enough to get people to follow the rules, those people on the edge who don't do what they're supposed to do. And so now we have these increased penalties. So for those who don't already have a plan, they have enhanced the tax credit for small employers. It has to be for employers with under 100 employees, and then it increases the cap times the greater of $500 or the lesser of $250 for each non-highly compensated employee, or $5,000 participator, $5,000. And so the idea here, again, without getting into the technical nature of it, is they're hoping if they offer small employers more tax credits, more small employers will start plans. Generally, there is a trend, or if you did statistical analysis and you looked in surveys, smaller employers with smaller numbers of employees do not have retirement plans, and that most of the folks in this country who have access to retirement plans, it's when they work for larger employers. And so this is another effort to get folks into plans. You compare this to the efforts in some states where the states have taken this issue up on their own and required small employers with certain number of workers to participate mandatorily in state programs, and this might be the federal government's somewhat response to that, to make it a little bit more palatable for those small employers to start plans under the normal scheme like the rest of the employers. So, for all those people out there who don't have access, that's the goal that they hope that goes to. So, okay, let's talk about lifetime income. Again, another disparate topic, really no connection to anything else we've talked about so far today. I'm sure it's feeling a little head spinning for people. So one of the issues with lifetime income products, meaning annuities, right? Another name for them are annuities, although they're not always called that in the retirement plan context. The idea is I put a certain amount of money into a product. I then get a guaranteed payout from that. That's just one way of doing it. I get a guaranteed payout for the rest of my life, $1,000 a month, $1,500 a month, and so on. The problem with some of these products is that they are very dependent on the platform the plan is on. For anyone on the call who's done research on this, they know that these are not products that all the time are generally movable, applicable to different platforms. And so the government and those of us in the industry want to see an increased use of this because from a policy perspective, this again helps savers, helps participants know that they can lock in that income and they have the money they need to survive and thrive in retirement. And so there's changes here in that if a participant gets in these products and then for some reason the plan sponsor doesn't want to offer it anymore, not only has it not been portable, but the downside is that you then, to get out of it, you have to pay penalties, because typically for the insurance company or the provider to guarantee payments, they have to have certain guarantees and finances over the money. And so there's penalties when you take your money out early, typical annuity stuff. And so the idea here is participants may take a distribution of the lifetime income investment, meaning they can move the investment to an IRA or maybe another plan if the plan allows it, if the lifetime income option is no longer authorized as an investment under the plan, and distribution is made to another retirement plan or IRA through a direct rollover, or if it's an annuity contract by direct distribution to the individual. And this applies to tax-qualified defined contribution plans, 403B plans, and 457B plans. And so as lifetime income options increase in popularity, as providers offer new products, this hopefully will be a good change to see more of those products develop in the industry. Closely related to that, participants are now required to receive statements that discloses their balance in the equivalent of a lifetime income stream. So it's going to state their monthly benefits in the form of an annuity or joint and survivor annuity, and they're supposed to receive it at least one time per 12-month period. The problem with this has always been, this has been a good idea, because some people don't understand, okay, I have a $90,000 account balance. What does that mean for me? Well, that means a lot of different things to a lot of different people. For a low-wage worker, that might be all the money they need when combined with Social Security. For somebody who's middle class, that might not be enough. People have different issues translating that into what is this going to be for me for my lifetime what's out there. So this was an attempt to translate account balances to something more akin to what people would receive under old school defined benefit plans. The kind that my grandfather had working for RCA for 47 years. The problem is there's completely different assumptions that can be made, different mortality tables, so many different inputs that there's no standard way of doing it. And so people have struggled to get it on and required for a long time. There were efforts inside the DOL to do this as a regulation. Now we're finally seeing it as part of a statute, but not right now. Why? Because the DOL has to offer within 1 year of enactment, so starting by the end of this year, they have to put out a set of regulations that allow what the permissible assumptions are. They need to issue a model lifetime income disclosure, so they're going to tell us what that should look like, and they need to issue interim final rules. And so stay tuned on this one. I personally think that this will be a great move for people. It will be eye-opening for people to know how a $40,000 account balance compares to a $200,000 account balance compares to a $750,000 account balance for their lifetime, and for them it will help people plan better. The other side of it is people really hope, and this will be an opportunity for education with your advisors later on, and maybe I'm stepping on Dave and Joe's toes a little bit, but that if your participants now see that their current account balance is only worth $150 a month in retirement, no one can live on $150 a month. And so it may end up being quite a fire under people's bottoms to get them to save more during their working years. And that really is the ultimate goal, if I haven't stated that explicitly. So for me personally, I think this is a good move and a good plan, and one more arsenal in everyone's tools to get people to save more, as the requirement and duty to save has been shifted more to the American worker and less from the American employer, like it was, again, a generation ago when most people received, or a lot of people received, defined benefit plans. So third lifetime income option change, somewhat related to the last two, is we got a safe harbor for the selection of a lifetime income provider, I believe in PPA 2006. But for people like me, ERISA attorneys who advise plan sponsors all the time, there were some shortcomings in that safe harbor that very much felt like a catch-22 and a gotcha for those plan sponsors, that if you could do everything right, investigate the different lifetime income providers, look at all the information that was available that they would offer you about their products and their longevity and survivability as an insurance company, but if something went wrong or you missed something, you kept fiduciary liability. Even with the safe harbor, many plan sponsors concluded that there was still too much risk in selecting a provider. And since selecting a provider was voluntary and not mandatory, why am I even going to offer this product? Why am I even going to go, try climbing that mountain? Forget it. I don't have to do it. I'm not going to take the risk. And so that has been, I believe, much of the reason, at least in my conversation with my plan sponsor clients, why we haven't seen more lifetime income offered. And so this is an attempt to further refine the safe harbor that reduces the risk for plan sponsors for being responsible for future failings of those insurance companies, as long as at the time you jump through certain hoops and you're allowed to rely on representations under state insurance law and all of that. It just gives plan sponsors out there less risk to make this decision to offer these products to their plan participants, which in most circumstances are going to be in their best interest, but it was scaring people. So now further refinement, less risk, more reward. So we will see more information on this in the future, like a lot of these provisions I'm talking today. So RMD rules, the max contribution age for IRAs right now is 70.5. It's now going to be 72. There is no more. So if I'm working till 85, I apologize. If I'm working till 85, I can keep saving money till 85. Of course, the only issue there is I still have RMDs, And so I'm still going to have required minimum distribution starting now at age 72 instead of 70 and a half. So really, this is going to be an issue for the financial planners out there in the world, and your employees who work with financial planners and have carefully been putting this together. There's more to come on this. The IRS has to update mortality tables and so on. But this was a recognition again of older workers. And so we will see. The RMD rule change for your plans to 72 will be one of those changes that will come out. Your providers, more likely than not, will be giving you updates, and we'll see those changes soon. Okay, so, but at the same time, stretch IRA is not sure if everyone knows what a stretch IRA is, but it was the idea that the beneficiary of my IRA could benefit from the tax deferral for a number of years after the death of the person who bequeathed it. My understanding is even to their own. And so now the government doesn't like the extended tax deferred nature of that, and they want to rein it in. And so now it's going to be that you have to distribute all of that money within 10 years over certain things. And so again, more of a financial planning topic, not 100% applicable to plan sponsors on the call, but just know that that's out there and that change has occurred. And so if you have your own financial planning meetings, you're going to want to be talking about that. And making sure it's covered in education meetings provided to your participants by your plan advisors. Again, more rules on that, but we're making time here. I want to make sure we have enough time for Joe and David. So another change. Plan can be adopted with a tax return. This is, again, for those who don't have plans. The prior law required taxable qualified plans to be adopted by the last day of the taxable year. So if you wanted a plan for 19, you would have had to do it for December 31st. Now you can do it up until the date of the tax return is due, so potentially the beginning of April, including extensions. So that really creates more flexibility for those establishing plans. It's, again, good for employees who then get one more year to have opportunity to defer. So one additional thing that they finally got the Cadillac tax on high cost group plans eliminated. That came as a result of ACA. That could probably be a whole nother topic for a different PowerPoint and a different day. So let me get into MEPs and PEPs quite quickly, and then we will jump over to David and Joe. So for many years, we've had available multiple employer plans. That is not, most people get this wrong. I'm going to teach everybody a great little mnemonic trick that I teach my students when I teach as an adjunct law professor. Multi-employer plans are union plans. And the reason you could remember is that the word multi has 5 letters, as does union. I know very many highly accomplished ERISA attorneys who get that wrong accidentally. Multiple employer plans are not union plans. It's when you either have a closed multiple employer plan of close employers with a common nexus. So printers, there's been a big push in the private university space. We see small private universities coming together under a closed MEP and pooling all of their assets together for economies of scale and so on. And then on the other side of that, we've had open MEPs tried to be popular a number of years ago. There were some roadblocks that we don't have enough time on today's call. The biggest one being the bad apple rule, the idea that if one employer screwed something up with their adoption of the MEP, it disqualified the entire plan. So you could disqualify, 500 other employers if you had a qualification error. That scared a lot of people away from adopting MEPs, but they're still out there. And so the industry has been looking for a solution that moves some of the risk of sponsoring plans. There's been a lot of very smart people out there who feel that the risk associated in the administrative burden, and I'm sure everyone on the call today knows that. That's why you're listening to me. The administrative burden in sponsoring a plan is great. And so can we come up with another solution for a way to maybe pool everyone's plans together, share that administrative burden in a way that makes sense, that protects participants, protects just from all aspects, and protects the employer. So what we now have are pooled employer plans, or PEPs. So MEPs are still there. Those haven't been eliminated, but now we have pooled employer plans, and the bad apple rule does not apply. So that's some of the highlights and the biggest change. And so Again, the bad apple rule is gone for PEPs and also for closed MEPs under the current law. So what is a PEP going to look like? A PEP has to have something called a pooled plan provider, or a PPP. This entity or person or company is going to have to take on named fiduciary status as a 316 plan administrator. So again, that offloads a lot of the responsibility from the employer to this new provider. They're going to have to register with the government, with Treasury, and be subject to audit, examination, and investigation. They're going to have a high ERISA bond and have certain disclosure requirements and acknowledge their status as a fiduciary in writing. This is probably in the marketplace. If the marketplace develops correctly as intended under the law, these are going to be very professional providers. You're going to see record keepers taking on this status. You're going to see advisors taking on this status. You could even see lawyers and law firms taking on this status and potentially sponsoring PEPs. It remains to be seen how the marketplace will develop. Employers will be required to designate the PPP. They're going to be required to designate a trustee to collect contributions. They're going to be co-sponsors of the PEP, but under the law, the only fiduciary responsibility that they'll retain is appointing and monitoring the pooled plan provider and investing plan assets, unless you also delegate that. So this is going to be a very interesting experiment to see whether there's an appetite amongst America's employers to offload as much responsibility about retirement plans as they can. I think the general thinking right now is we're going to see this more on the smaller side of the market. Smaller plans will do this, where the larger companies, mid to larger companies, will not, because they will want to retain control over their plan, especially those with custom plan documents and complicated workforces. And so it's just going to be another tool in people's arsenals. But again, the idea is increased plans, increased coverage, and the added benefit to employers of offloaded rules. So again, we already talked about the one apple rule. We'll skip over that for now. But none of this is happening right now. The IRS has to issue a model plan. The IRS has to issue additional guidance. They claim that there's good faith reliance until then, but I find it hard to believe that providers will start offering this now without that guidance from the IRS. Nobody's going to want to potentially screw up. And so this is after 2021, so stay tuned. This could be a really big deal in the retirement space. So, and also one of the added benefits is only one Form 5500 for the whole PEP plan. So you could have 1,000 employers in there and only one 5500. So that's another added benefit of this. So at that, I'm going to hand it over to Joe and David. I hope that's been informative. Again, I'm sorry for the disjointed nature, but I'm going to hang out on the call and be available for questions later if people have them.
Great. Hey, thanks, Tom. I appreciate that. Yeah, this is a complicated one. So this is very clear what you put across there. So thank you very much. I want to ask Joe some questions. Joe, you've been an advisor for close to 30 years. You've lived through these past changes. Cut through some of this. What do employers need to know? How are you going to start the conversation, or how are you going to have a conversation with them about the changes?
Yes, David. The first and foremost, we need to really educate folks on what's required and what's optional. So sometimes that gets lost in the conversation, but we know through Tom's presentation that the issue around part-timers is required. So certain employers need to deal with that. The lifetime income disclosures on statements required, RMD rules. So basically, we really need to just cut through some of the noise and figure out what's required first, because most employers need to deal with those. With the possible inclusion of part-time employees, remember the rule states, as Tom mentioned, employees age 21 or over that work 500 hours or more for 3 consecutive years must be treated as eligible. So that means they can put money in the retirement plan. But since the effective date of this is 12/31/2020, it's a good time now to ensure that you have systems in place to properly track hours. Effectively, the soonest a long-term part-time employee must be allowed to contribute to the plan is 2024. But we're urging people not to wait. Being prepared is key. Dealing with many of our clients, their systems do track hours properly, but they sometimes get lost. Tom mentioned an example of seasonal part-times who serve overtime during the summer or whatever that season may be that the business ramps up. We have a manufacturing client that has some seasonal demands, and those folks may get 500 hours for 1.5 months when they're working there, and they do that every year pretty consistently. So we need to make sure that they have something to track that now, because if it starts in next year, really we want to track it for the next 3 years. So when 2024 comes around, we can comply with that. And then there's something that not many people are talking about with the part-timers. It is not required that employer make a contribution, but it's also not excluded. So some companies who have long-term part-time employees may want to put some employer contribution or match in there to encourage their folks to participate. So that's right now, if you fall in that with your workforce, you may want to consider putting that part of the budget process now, so it doesn't come for a surprise or a quick decision when 2024 hits. But as Tom mentioned, final regulations are still needed for clarification around some of these, so it's really important to stay tuned. When it comes to the required minimum distributions, there's one real important thing that Tom mentioned there that we need to remember that this rule does not take effect. It does not affect people that already hit 70.5 before 1/1/2020. So if for some reason you have folks that are already taking required minimum distributions out of your plan, those folks need to continue to take those required minimum distributions. This is more of a question for you to ask to your record keeper TPA. Many of you may not have people taking required minimum distributions out of your plan. They may have rolled them to their IRAs, so they're off your books, if you will. But it's important just to understand the technical aspect. For this year, we are going to be on the fence. Some people already turned 7.5 towards the end of the year, and they are taking their distributions or should take their distributions by April 1st this year. We just want to make sure that your record-keeping system or your third-party administrator identifies those folks so we don't get them hung up because there's some severe tax penalty for those individuals who do not meet those requirements. And then finally, something that employers really need to know about, and this is more the optional side, but the flexibility around the new ways we communicate safe harbor and how late we can add a safe harbor provision to the plan. The action item here is, take a look at mid-year testing. It may be appropriate if you're having issues with your discrimination testing. It may be appropriate to add a safe harbor to your plan. The new rules allow you much more flexibility on not only not having to announce it, but in the timing of when you can actually put the safe harbor, declare the safe harbor plan within it. So I'd say that's really, for right now, that's what you need to know. But start with what's required and then determine if your systems are set up to meet those requirements.
Yeah, that's great, Joe. I think one of the biggest things I took away from what you just said is not just the reg change, but really how you prepare for it. And that's a key piece of this because, different folks have different systems, and that preparation is going to be critical because no one wants to be in that situation where they're trying to do something last minute. That's when mistakes are made. So I think that's really helpful. Can you go into a little bit more just from how, there's a lot of service providers that sort of hover around this area. You touched a little bit on the record keeper and how they planned this. What other direction are you giving to clients around how they work with other service providers, specifically the record keepers? Is there any other guidance that you're giving there, or still kind of just on the starting point here?
Yeah, I would say we're on the starting point because a key point is secure includes language designed to ensure that amendments to plan documents are most likely not necessary until the end of 2022 plan year. So to start, there is going to be some time because again, all your systems, your record keepers or third-party administrators, they're 23 days in on this thing. So they're figuring out how to address the plan amendments. But something really important, although we have till 2022, to the end of 2022 plan year to amend their documents, or that's what it looks like in the secure language, plans will need to follow the new mandatory provisions from an operational standpoint immediately. So although Tom said the house is not on fire because it's not, there are some things that we have to do instantly when it comes to the requirement. And again, the requirements are the annuitized amount of an individual's account balance on a statement. Many of you probably already have that with your record keeping systems. So I'll talk about that in a minute when it comes to opportunities, I think, but that's important. But this part-time thing, you may be sitting here saying, well, that doesn't really impact us. I would have somebody in finance or payroll do a quick run over the past 3 years and see if that does impact you, because you might be surprised at that one. And again, If you deal with a lot of interns, remember this rule does exclude folks who are prior to age 21, so it may not hit you. But now is the time, really, the message is now is the time to work with your advisors, to coordinate with your third-party administrators and or record keepers, just to make sure that you're going to be ready for this. And I would discuss each optional provision to determine which ones are appropriate for your plan, your workforce, just as part of your overall benefit strategy. For example, if you decide to include the new birth adoption option, work with your record keeper now to determine the timing of when their systems are actually ready to record keep this benefit. Because we're talking to a lot of our clients right now, and most of them say, yeah, well, why wouldn't we want to add that? Well, yeah, we'd probably want to add it, but we want to make sure that the systems from a compliance standpoint are operational. So we may add it in 2020, but we're not going to be so quick to advertise it in January of 2020 until we understand that our systems can support those distributions.
Got it. And so you talk about opportunities. And so let's say a client comes to you and says, hey, we really want to make our plan more competitive. That's a focus of theirs. What are the things that they can take advantage of if, as they try to retain talent or recruit new talent? What are the key pieces of this where you would come back and say, okay, great, here's what you can do now that you couldn't do before? What are the opportunities there for employers?
I'll cover two quickly because I think one may be overlooked, but the one that has some really the ability to make the plan more competitive is by increasing the auto escalation cap from 10 to 15%. So if you have auto escalation, you probably just went to the default of starting somewhere, auto enroll at 3, 4, 5%, let's say, and then you did the escalation cap to 10% because that was the prior safe harbor rule. I would definitely consider changing that to 15%, although that's an optional provision. What we're finding, David, is many of the plans we are working with are now hitting the 10% caps. So meaning they've had auto enroll for 4 or 5 years, and they're now hitting the 10% cap. And when we look at the data, there has been very little drop off of participation from their employees. So in other words, they're getting to the 10% and they're fine. They're continuing to put money into the plan, but now the employer is stopping them at 10 because that's what their plan says. So I think it makes a lot more sense to increase to 15 because folks who don't want to go as high as 15 will stop. But this may also necessitate a discussion around offering other types of benefit plans, like a non-qualified plan, for example, as many folks are proving that they want to save more, but due to IRS limits, they just won't be able to save that 15%. So I think it's a good time to have that discussion around, hey, is there a next level of retirement plan like a non-qualified plan? But again, this goes back to your overall benefit strategy with your workforce. So I think that's one. And then two, there's a huge opportunity that is presented through the safe harbor rules around adding lifetime income options to your plan menus. Tom discussed a little bit of the current state and why some folks don't do it, but we view this as a way for employees to take advantage of guaranteed income in order to meet their retirement needs. Think of it as making the defined contribution plan like their 401k or 403b a little bit more like a pension plan of the past. As Tom mentioned, most folks have a balance in their plan, but they have difficulty converting to what that really means to them. So we figure if we can add lifetime income options to plan menus, it would really make a lot of sense for folks and will actually drive savings rates up. So at this point, what we're really doing now, the practical matter is we are in the wait and see mode for a few reasons. One, as Tom mentioned, we talk about letting the marketplace catch up with the appropriate products that provide competitive pricing for your employees and figure out the portability issue. I mean, those are really key. And then the second is, there's further guidance or regulations that will have to be drafted around this rule. So although it sounds great, a lot of employers that we're talking to are gung-ho about adding this option, the market is not caught up to the actual regulation yet. So I'd say let's wait a little time. And to this point, when it comes to opportunity, this is something you may want to think about here and now when it comes to lifetime income. We are rolling out extensive education to employees around this lifetime income projections that they are seeing on their 401k balances and statements, because this does two things. One, it gets folks focused on their retirement benefits, basically what they will have, or will they have enough when they retire, or are they saving enough? Those are really important points. But the second is it sets the table up for when income products are appropriate for your plan, that this is not a brand new conversation for your employees. So if we can convert folks from thinking about looking at their balance in their 401k plan into actually considering what income they're going to have in retirement. When the income products are available, and if they do make sense for your plan, folks will already be thinking along those lines. So it'll be a more natural progression to educate them on the pros and cons of doing an income product so that they can make the decision, is it appropriate for them or not.
That's great. No, that's extremely helpful. And I think I just want to be sensitive to time. We've just got a couple of minutes left here. So maybe, Joe, what I'd ask you to do is sort of bring this, summarize this with a takeaway and some actions, and then I'll close it out when you're done with that.
Certainly. So I think it comes down to next actions. And I would think the one thing that Tom mentioned is you got to be vigilant about your filing of your 5500s and tax documents, just to avoid these new penalties. When we were on Capitol Hill talking about the Secure Act, one of the themes that we heard over and over from the enforcement agencies were like, yeah, this is all great, and we realize we have to get American savings, but we need data back from plan sponsors, and it's too lax when the timing of these issues. So they are serious about the penalties. I don't know if they're staffing up for them at this point. I have no insight on that, but I would say the fact that this was mentioned in the Secure Act several times, I would take the filing requirements very seriously at this point. And most of you on the phone probably have already. Again, I talked about the part-time employees, so I'd make sure the systems are ready to start tracking them in 2021. This gives your payroll and HR and finance departments time to make the proper projections. And then I would encourage that all savers consider the impacts of the changes to the stretch IRA. This is few and far between, but when you're doing employee education, for example, I think your record keepers are going to start having this information on there, but it might be something noteworthy in the conversations you have with folks, especially if you do specialized education for folks preparing close to retirement. And those of you on the phone that are thinking that the MEPs or the PEPs may be a better option for you, I would just watch for further guidance, and I think we're several months away from that. So with that, I kind of say, sorry, I got a very fat finger on my slides here. What I would say is, there are a couple actions. Again, if you don't have a plan, now may be a really good time to think about adopting the plan, even if it's after the tax year. We talked about the RMDs. The lifetime income options, I spent some time on that because I really don't want to just write that off as, hey, something that's buried in the Secure Act. This is one of the main themes of the Secure Act. This and getting folks into the plan, what we call coverage. So I think the lifetime income options are something that if I was in HR, finance, if I was in a fiduciary capacity retirement plan, I would really start paying attention to this. There's so much information out there through many different sources. So I would start to pay attention to this and make sure this conversation is happening now. And then if, as I mentioned, I would consider taking advantage of the liberalized safe harbor rules if your plan, again, it depends on the size of the employer, but if your plan's running into some testing issues. And I don't see any reason not to implement a qualified birth or adoption distribution. So there are a lot of takeaways from today, but the main thing is, first and foremost, as I mentioned, realize what's required versus what's optional. The required, you're going to have to do. The optional, I would start having those conversations now with you and your committee so that when the time comes, it makes it simple for you to make that decision if it's right for your plan and your workforce.
Great. Thanks, Joe. And I think if you can go back to that text hub page there, I think
I'm trying, David.
I want to thank both you and Tom for joining. It was great content on its own, and how this may impact the employers. I think that's the critical piece about this. This isn't a change that you want to figure out on your own. You're going to need to get advice and work through this because every situation is going to be different. The good news is there's more content to come. To access this content and stay in the know, please text HUB to 888-111. So text HUB to 888-111, and you'll get an email back with a bespoke link to HUB on the Secure Act so that you can follow what's going on, and we'll continue to update that, not just from the legal side, but from the practical side of what that means and how to implement and what you've got to be thinking about. So we'll be focused on both sides of that. So with that, I'll thank everybody for joining, both presenters and the employers and folks on the call. So appreciate it. Thank you very much, and have a great day.